Good afternoon, and thank you for joining us in our session today. I'm Hugh Dyer. I'm a counsel in the Toronto office, and with me are my colleagues Ina Koldorf from the Vaughan office and Shayla Klein from the Calgary office. We're all members of the Labour and Employment Group with Miller Thomson, and very pleased to speak to you today. Everyone, just a few housekeeping notes. Everyone's been placed on mute. If you have any questions, please put them in the chat, and we'll get back to you as soon as we can, if possible today. In case you need technical support, please find the help button below the video window, right next to the Return to Agenda button. And just one note, this presentation is for information purposes and does not constitute legal advice. Please contact one of our lawyers if you need more detailed and specific advice. Okay, next slide, please. And next slide after that. Well, I'll just introduce our topic. Our topic is social media off the clock where policy meets privacy. So that's our topic. Those are the speakers, and let's go to the agenda. Next slide, please. Okay, this is our agenda for this session. We're going to talk about an arbitration which was subject to judicial review by the Divisional Court and then by the Ontario Court of Appeal. It's Metrolinx and ATU. Some of you may be familiar. It's been a decision that's been discussed quite extensively, but the most recent decision from the Court of Appeal is worthy of note. I'll be addressing that just as background for the rest of our presentation because that case touches on a lot of the issues that are part of this discussion today. Shayla will then be addressing the legal test when can you discipline, examples, duty to investigate, formal complaints and not required, and then privacy considerations, and Ina will be addressing practical tips. And as I said, if we have time, we will get to questions at the end. Okay, next slide, please. Okay, just a brief overview of the facts in the Metrolinx case. It was an arbitration under a collective agreement between Metrolinx and the Amalgamated Transit Union. There were 5 employees who were discharged for harassment. They ranged in service from 7 to 10 years. None of them had any disciplinary record. It was all involving off-duty and outside of workplace conduct. The principal behavior was an exchange of comments through a WhatsApp chat room, which the participants believed to be private and was, for all intents and purposes, private, except that Ms. A, who was one of the people referred to in those messages, saw some of the texts and was upset by them. None of the other people that were the subject of the text saw them, as far as we know. Management, however, learned of the texts through Ms. A. They conducted a lengthy investigation, during which the investigator required one of the grievers to disclose those texts. It's important to know that Ms. A, who saw the texts, did not want to complain, did not really want to be part of the investigation any further. Next slide, please. All of the grievances were allowed. The arbitrator found that the texts were private. There was no impact on the workplace. He found, an arbitrator's name was a gentleman, they found that the employer violated its own policy on workplace harassment. It violated the timelines for pursuing the investigation. There was no complainant, and the arbitrator found that there had to be a complainant. That was a significant finding for the arbitrator. And he found that the employer was actually in a conflict of interest because it was, in the arbitrator's view, both complainant and investigator, and one shouldn't investigate one's own complaints. They also found that it was improper for the employer investigator to require one of the grievers to disclose the texts as they were private, and finally found that the employer misapplied its zero tolerance discipline guidelines. Next slide, please. The employer applied to the divisional court for judicial review, and in 2024, the divisional court decided that the award was unreasonable and therefore quashed it. And in particular, the court found that the arbitrator had failed to recognize that the employer had a duty to investigate. Under the Occupational Health and Safety Act, which is the governing legislation in Ontario, employers have an obligation to deal with either complaints or incidents that may have involved harassment. And the court found that this was at least an incident, and therefore the employer had an obligation, a duty under the Act to investigate. Secondly, the divisional court found that the arbitrator was wrong about the conflict of interest. There was no conflict of interest because the employer was not both complainant and investigator. It had an obligation to investigate the incidents that were in dispute or in question. And finally, and perhaps most importantly, the divisional court found the behavior was not entirely private, as Ms. A was aware of it and she was upset by it. And lastly, the court doesn't decide this, but it indicated or suggested at least that discharge may not have been the appropriate penalty for the discipline in question. Next slide, please. Now, this is the Court of Appeal decision, which was issued earlier this year. And in labor arbitration, we don't get decisions that go to the Court of Appeal very frequently. And when we do, they tend to carry greater weight because they come from the highest appeal court. So therefore, this case is of some significant bearing on arbitral practice in this province. The union appealed the divisional court decision to the Court of Appeal. The Court of Appeal, however, dismissed the appeal, and they agreed to a large degree with the divisional court. The Court of Appeal, though, emphasized one particular point that the divisional court didn't emphasize quite as much. The Court of Appeal had said that the arbitrator placed way too much emphasis on the fact that Ms. A did not file a complaint. The fact that she didn't file a complaint was her choice. The arbitrator suggested that the fact that she didn't file a complaint suggested that the behavior was not as serious as, or not harassment even perhaps, because she didn't file a complaint. The court said that's all incorrect. The employer had a duty to investigate in the circumstances, even though she didn't file a complaint. And Ms. A may have not filed a complaint for a whole bunch of reasons that don't relate to the fact that whether or not it was harassment or not. Secondly, the Court of Appeal agreed with the divisional court that there was no conflict of interest. The employer had a duty to investigate incidents as well as complaints under the Act, and therefore it wasn't in a conflict of interest as both complainant and investigator. Thirdly, the arbitrator had found that there was no impact on the workplace. Court of Appeal agreed with the divisional court and said that there was an impact because Ms. A saw the texts, or at least some of them, and was upset by them. And finally, and this is an important point for those who are doing investigations and relying on the results of investigations, the court found that an investigator could, in these circumstances, insist on the disclosure of the texts. And that is a very significant fact because that was a critical piece of the evidence before the arbitrator in this particular case. And the final decision of this is that pending an appeal to the Supreme Court. I do not believe it's been appealed to the Supreme Court, but I can't say that for certainty. The grievances are to be considered by a different arbitrator who will look at the facts. The facts were largely agreed in this case, which was quite interesting for a case of this nature. There's a long, thorough agreed statement of fact. And so it'll go back to a different arbitrator to see what he or she may decide as to the appropriate outcome. And now I'll turn it over to Shale.
Thanks, Hugh. We can advance to the next slide. Hi, everyone. I'm going to talk about the legal test. So we've got that great example of a case from Hugh. It's an Ontario Court of Appeal decision. And as Hugh explained, it's a labor arbitration decision that was later appealed. And it is in Ontario. However, I'd like to highlight it's certainly persuasive and indicative of decisions across the country and also outside of labor context in terms of just an employment relationship where there isn't a union involved. In terms of the legal test, when can you discipline for off-duty conduct? The courts have confirmed that employers can discipline for off-duty conduct when what's happening outside of the workplace manifests in the workplace or bleeds into the workplace, and there's a real and substantial connection. So there needs to be some movement or exchange into the workplace, in this case with Metrolinx, where Miss A became aware of the information and the things being discussed about her in these private chats with her colleagues. So that connection and that impact in the workplace must be real and substantial. It must seriously prejudice or injure the employer's reputation or other legitimate business interests. And here the onus is on the employer. So it's the employer who, if this gets appealed or if there is a wrongful dismissal lawsuit after the fact, who is going to have to lead evidence to justify that there was a real and substantial connection to the workplace and that there was an impact in the workplace that wasn't just trivial. Real and substantial connections to the workplace can include a variety of factors, and every case will be different and will be circumstantial based on the facts specific to that case, but it can include a review of the nature of the employee's duties, those who are committing perhaps this improper off-duty conduct, as well as those who it's impacting in the workplace. The employer's expectations and their policies in particular, it can be quite helpful for an employer to be able to rely on a breach of its policies, in particular, probably their social media or anti-harassment policies, as well as history and quality of the employee's conduct, seriousness of the conduct, and the impact on operations overall, as well as on employer reputation. Next slide, please. That impact can look a variety of different ways. It could be reputational harm. So we're talking about damage to company image or credibility. It could be an impact on clients or serious customers of the organization. It could be operational harm, so interference with business operations in terms of not being able to perform duties or continue with the operation of the workplace. It could be that it's affecting safety or trust, so that employees aren't feeling safe. That might include that they're not feeling psychologically safe in the workplace, or that there's an impact in trust such that there's an erosion of trust, either perhaps between employees or more importantly between the employer and another employee, that the employer can't trust an employee any longer because of this damage or this knowledge that's happened outside the workplace. Also, if there is an affective job performance, so if employees are unable to, unwilling to, or reluctant to continue their jobs or work together, in particular, if two employees that are involved in this off-duty conduct work closely together and that's causing an impact that can be concerning. Other considerations can also include a serious breach of the criminal code harming the employer's general reputation, or if that comes into play with certain policies. And it's important, as is discussed in this Metrolink case, that there be proportional discipline. So with any discipline, of course, employers are assessing whether the action they're taking, if it's a written warning, if it's a suspension, a termination, if that's proportionate to the behavior or the misconduct that's actually occurred. So the court will still be looking at that to see if whatever discipline that comes out of an investigation is actually appropriate in the circumstances. Next slide, please. So I find it helpful for us to talk about some examples and the kind of things we're discussing here. These are the sort of situations that we mean or that we've encountered. So examples include where employees are posting derogatory or confidential workplace content online. So they could be posting negatively about each other, about a supervisor, about a customer, about a brand, anything like that. Anything where confidential or proprietary information might be shared online. that those would all be breaches that we're discussing. Examples of harassing, bullying, or threatening coworkers outside of work, and that could be a direct threat to another coworker, or in the Metrolinx case, more harassing and kind of in joking behavior in terms of negative and inappropriate things to say about a coworker who's not a part of the chat. It could be sexual harassment or assault of a colleague off duty. Prior to the extreme rise in social media, these are sort of the traditional off-duty conduct cases we're talking about. For example, two employees go home after a company golf tournament, and then one alleges that there was a sexual assault. This kind of situation where it's outside of work, but now it's affecting the workplace. It could include publicly criticizing or mocking your employer or supervisor, and also general discriminatory or hateful conduct online tied back to the workplace. Next slide, please. So as already highlighted by Hugh, the duty to investigate, this is old news. This is reiterated in this case, but it's certainly not something that is new. Occupational health and safety legislation across the provinces requires employers to investigate complaints and incidents of harassment or violence. And the Court of Appeal said an employer's duty to investigate is not just a duty owed to the victim, but to all employees who have a right to work in an environment free from demeaning and offensive comments. So it's not prohibitive that the individual who is being subject to this harassment or this negative behavior makes a formal complaint. Sometimes we do receive inquiries from clients saying, we asked if this individual wanted to file a complaint and they don't want to. So is there anything we can do, or can we do nothing? And you still have an obligation as an employer to take further steps. Anonymous complaints, informal complaints, or indirect complaints from another witness all trigger this obligation to investigate. And just because an employee does not want to submit a formal complaint does not mean you do not have to investigate it. Next slide, please. And just a note on balancing privacy interests. As Hugh said, in that Metrolinx case, the employer required that in one of the grievers turn over copies of the WhatsApp text, turn over the receipts, if you will, as part of the investigation. And the employees alleged that this was in breach of their privacy rights. And the court said that while employees do have a right to privacy in their personal lives, this is a balancing act. This right may be limited where there's legitimate workplace interests at stake, and employers are entitled to inquire into off-duty conduct when it's affecting these things, when it's causing this real and substantial impact in the workplace. And also further, employees who continue to work at a workplace have an obligation to cooperate in workplace investigations. They can't be obstructive. So even if the conduct's occurring off duty, they have that obligation to participate in a meaningful way. And if they refuse to, then there can be additional consequences for that. Overall, we just highlight that balance is required, and respect must be weighed against the employer's responsibility to maintain that safe and productive workplace, in addition to the individual employee's privacy rights for what's happening outside of work. Next slide, I'll just pass it over to Ina.
Thank you, Shayla. Hi, everyone. Shayla's told us a little bit just now about the tension that exists between respecting employee privacy interests and protecting the business when the company has to investigate off-duty conduct. And in this next section of our session, we're going to give you some practical tips to navigate the sticky situations that Shayla and Hugh have raised in their presentations. One of the best ways to avoid these potentially messy situations is to proactively prevent off-duty issues before employees go rogue on social media. And the purpose really is to set clear expectations up front, because if employees know the rules in advance, the chances of later disputes is reduced. So start with setting clear rules. Your organization should have a written social media policy, which should clearly define what constitutes acceptable and unacceptable online behavior, even outside of work hours. Excuse me. And include examples of anything that could harm the company's reputation, such as disclosure of confidential information or involvement in harassing or discriminatory behavior. And make sure that the policy also includes consequences for violations, and that those consequences are explicit in the policy, because this helps employees understand boundaries and reduce ambiguity. Then train the employees on the policy and the expectations. A policy, as you know, is only effective if employees understand it. So conduct training sessions using real world examples of social media missteps and their consequences. And really the easiest way to do that is to pull fact scenarios from cases that have already been adjudicated because you know that those things have reached the level of a hearing and you know what the adjudicator has said about them. You should also show how online behavior reflects not only on the company, but also on the employee's professional reputation. So make it personal to them. As an organization, you should promote positive conduct. So encourage your employees to use social media responsibly. Highlight positive examples of employees who represent the company well online as examples. Make sure that employees have a safe, confidential way to report concerns. This could be a dedicated HR email or hotline or a whistleblower hotline or service, and reinforce that reporting will not result in retaliation. When employees know that there's a trusted, confidential way for them to raise issues, this could really prevent small incidents from escalating. Make sure that you lead by example. As with every other situation at work, leadership sets the tone. Managers should actively demonstrate proper online conduct and consistently reinforce expectations. And this shows that the company takes its social media policy seriously and that everyone is accountable, not only frontline employees. Keep your policies current. As you know, social media platforms and trends and risks evolve very quickly. So review your policy annually, at least, more often if you can, and update the policy if necessary. And if you are updating the policy, please make sure that employees are aware of the updates as well. Consider an annual refresher sessions or short newsletters highlighting the best practices or recent case studies, or even just the amendments that you've made to your policy so everyone is on the same page. And introduce social media expectations during onboarding. This is going to ensure that new hires understand company values from day one, and include your organization's social media guidelines in orientation materials, and discuss why responsible online conduct is important. Next slide, please. Now, of course, even with the best policies and training in place, issues still do come up. And social media moves fast, and sometimes employees will still cross the line. So that's when your focus should shift from prevention to response. Once you discover a post that you think is problematic, the first step is to assess the situation. You need to understand the context and the potential impact. Was this incident a minor incident? Does it look like a serious incident? Does it look intentional? Could you be misunderstanding the context or the content of the posts? At this point, if you are in doubt, it's always a good idea to run the post by someone else on your team, especially if you're on the fence, to give you an understanding of whether you're misunderstanding the post, which has happened. Next, you should document everything. Take the screenshots of the posts themselves, note the date, preserve communications so you have a factual record of what happened. And make sure you document the post exposure. Can you see how many followers the employee has, if this is a platform where the employee has followers? Can you see how many views and shares the post got? And take a screenshot of that. Take screenshots of really everything that you see. If there are comments on the post, take screenshots of all the comments, because that will give you an idea of what the audience thinks about the post. So make sure you keep a factual record of everything so you can determine next steps. And lastly, and this is something that a lot of employers forget, is look at the actual profile of the person who posts and make sure that, first of all, they are your employee. And second of all, you want to know whether your company's or a company's name is in the profile as the employer for this person. Next, you should check your policies and agreements. So you look at your collective agreement if you have a union in place, you look at the employment agreement and other policies that may be relevant. So not only your social media policy, but also your confidentiality rules, anything that has to do with the code of conduct or your harassment or discrimination policy, because those are really going to guide you with respect to next steps. At some point, it's also really wise to consult with your internal or external counsel, because first of all, you have to ensure that you comply with employment and privacy laws. You need to think about the company's legal risk when dealing with the employee. And as we heard, sometimes off-duty conduct does need to be investigated. And so your counsel can help you determine whether you need an internal investigation, external investigation, and what your next steps should be to manage the risk there. At some point, either at this point or a bit later, either you or an investigator will have to meet with the employee. And if you are the one who's meeting with the employee, explain what you observed and explain why it's a concern. And also point to any policies that are relevant to what is happening. And you really do want to point to those policies because later on you want to be able to rely on them if you're given consequences. The most important thing at this point is to listen to the employee's explanation because context in these situations oftentimes really does matter. They may have a perfectly good explanation for their actions. They may be using slang that you're not aware of, for example. There may be something in context or even the content of the post that may change your mind with respect to the seriousness of the post. And finally, if termination is involved, manage it with technology in mind. And what I mean by this is that you secure company devices, you secure email accounts. If this employee had access to your social media accounts because they were doing the posting or they were keeping data, make sure that those passwords are changed before the termination meeting. And of course, make sure that at the termination meeting, you advise the employee that they are not to make any more posts involving the company after termination. Not sure if you'll be able to enforce it. If the employee is signing a release, you might be able to, but there's no harm in mentioning it in a termination meeting. And I think I actually skipped one point, sorry about that, respond proportionally. Not every post that you think is inappropriate requires suspension or termination. Sometimes coaching is enough, sometimes a warning is enough. So really do respond proportionally when you're dealing with an employee about these posts. Next slide, please. So once you dealt with an incident, you'll wonder what you can do about preventing future incidents. And it all goes back to what we've already discussed, which is your social media policy and training. You need to look at every incident that happens as an opportunity to learn and to improve on your policy. And as we know, social media and AI are constantly evolving. And so your policy is going to be a document that constantly evolves as well. So let's finish with some tips on drafting an effective policy, which would hopefully reduce future problems for your organization. Start by defining the scope clearly, and that goes back to making sure that employees are aware of expectations. You should specify which social media platforms the policy covers, which AI tools or any technologies that are covered, so employees know exactly what's included. But of course, leave the door open as well to adding new platforms or tools or technology, because tomorrow or the day after your policy is published, something new can come around and you want to be able to capture it as well. Next, you should set expected behaviors, explain what professional, ethical, and responsible use looks like, including off-duty conduct. Make sure the policy protects confidentiality and data security. Employees need to know what information is confidential and is inappropriate for posting, and what is sensitive. And unless you are very explicit about what's covered, they may not be able to determine one from the other. You should also provide clear guidelines about AI if you don't have a separate AI policy. Lots of organizations over the last little while have created separate policies for AI, but if you don't have one, please throw it into the social media policy, because you do need some guidelines with respect to that area as well. Clearly explain the consequences of misuse of social media and AI. Employees need to understand the disciplinary measures and the importance of adhering to the policy. And if you have a progressive discipline policy, this will be a good time to remind employees of that, and to link it back to the social media policy, have them review and have them sign off on it. But at the same time, also encourage positive use. I've already mentioned this a couple of times, but train employees to ensure that they understand the policy, include the training and onboarding, include refreshers once a year, just make sure that people are aware of what's in the policy and how it's going to be used. And review and update your policy regularly. And lastly, like each one of your policies, enforce, enforce, enforce. A policy that is not being enforced is a policy that is useless to the organization. So if you don't enforce it, you will not be able to rely on it when you need it. So those are our practical tips for today. We do regularly get asked questions by our clients about this topic. And so we thought we'd share some of the more common questions that we get, and provide you with the answers that we typically give clients on them. And I'm going to kick it back to Hugh for one of the questions, and then Shayla and I will throw a couple in there as well.
Sure. So the question I have for discussion at least is, and based on the facts of Metrolinx as we understand them, was discharge the appropriate penalty, or is there some reason to believe that maybe it wasn't the appropriate penalty? Personally, if I can go first, answering the question I pose, it struck me when I was reading that case that for employees that had 7 to 10 years of service, no disciplinary record, there seemed to be, from what I could see in the decision itself, and I give you the caveat that obviously I didn't hear the evidence. I'm not as acquainted with the evidence as the lawyers would be that are presenting the case. But as I read through it, it seemed to me that there was a lot of the grievers admitted to a lot of the conduct. They specifically apologized to Ms. A and to others that may have been mistreated in these texts. It struck me that discharge was not necessarily the appropriate penalty. I know that the employer's policy said 0 tolerance for sexual harassment or for workplace harassment, but it's commonly accepted, I believe, in the arbitration community that just because the employer says 0 tolerance doesn't necessarily mean that everybody that violates the policy is going to get fired. It seems to me in those facts, while that behavior was inappropriate, quite likely I think an arbitrator would find that on when the arbitration goes forward, it strikes me that the penalty ought not to have been discharge. Ina and Sheila, any comments on that?
Certainly, I think the remorse from employees and also their willingness to participate in the investigation and not being obstructive in that context typically lead to lesser penalties than termination. I think it's probably helpful for our listeners to have a bit of an understanding of the text messages or the WhatsApp messages. And my understanding is that there was some conversation about certain female employees exchanging like sexual favors for promotion in the workplace. So certainly quite concerning comments, very negative comments, and definitely falling within those definitions of harassment and even sexual harassment. And having that 0 tolerance policy, I could see why the employer opted for termination. Although I think that if we were advising to that, we would certainly say that this isn't necessarily a slam dunk. There might be a risk here. I mean, we always say that often, but yeah, I agree. I think given the history, the length of service, and the remorse and cooperation and apology, it's likely that a lower penalty will be substituted when this returns to another arbitrator.
Yeah, I have nothing to add to that analysis. I agree with you both. And it'll be interesting to see what the next decision is there.
I agree. I agree.
Sheila,
Similar, maybe I'll catapult off that because I think a question sometimes we receive is when employees are refusing to participate in investigations. And so we talked about in this circumstance where the employees did turn over copies of the messages. However, I'm curious what your perspective is if they did not cooperate and whether that's different in the unionized context where they have an advisor there with them, a steward or of some nature. Would that have changed the outcome if they weren't cooperative? And are we talking about a different breach now in addition to the messages themselves?
you want to go first? I don't think it would have changed the outcome. I think it would have actually reinforced the outcome because then they are not, there is an obligation on every employee to participate in these investigations. It's typically in the employer's policy. Sometimes it's in the collective agreement, depending on the collective agreement. So I actually don't think that in this case, the outcome from the employer at least would have been different. And Hugh, your thoughts?
2 things. I'm reminded that there is a very traditional concept that when the facts are such that on the surface of things there seems to be a clear misconduct, an employee owes the employer at least an explanation. And if they refuse to give an explanation, that in and of itself may be worthy of some discipline. So a failure to cooperate in an investigation seems to me to be a potential cause for discipline in and of itself. But even if that's not the case, there was some degree of cooperation, and they did cooperate here. If they had been untruthful, or if the employee had refused, notwithstanding the investigator's request to produce those texts, that would have been a significant aggravating factor in terms of penalty. So I think that in that case, if those were the facts, there was a failure to cooperate or misrepresentations during the investigation, I think that would have probably strengthened the employer's case for discharge.
I agree. And I would say for employers dealing with a situation where employees are not being cooperative, certainly a clearly set out letter outlining expectations that they cooperate and their obligations, I think is probably the first step to see if that changes in terms of their cooperation. And then perhaps you're taking further steps after that if they're continuing to be obstructive. Ina, did you have one to add?
Yeah, why don't I switch gears a little bit and just talk about what happens during the investigation or when you find out that an employee had posted something on social media. One of the questions that we get asked often is, what if an employee's post doesn't mention the employer directly, but the employer still feels that the post harms the company's reputation? How should that be handled? Would you do anything differently? And the answer typically is no. That's a really common issue. Employees do sometimes name employers directly, but oftentimes they will allude to their employer, or the circumstances or the context makes it clear that they're talking about a specific company that they work for. You would follow the exact same steps. If you think that the post is going to harm the company's reputation, you would go through the exact same steps that you would go through if the employee had named the company directly. So do the exact same thing. And then the other thing, Shayla, before I throw it back to you, another question that we get asked quite often is whether we recommend that social media training be mandatory for employees, especially when you have a good policy in place, or just recommended. And we recommend that it's mandatory because, again, without you training your employees, if they don't know what the rules are, it'll be hard to enforce the rules afterwards. So you do the work ahead of time, and then if it's time to enforce the policy, hopefully you'll never have to, but if you do have to, at least you have the training to show that the employees understood the rules and knew that what they were doing, or ought to have known that what they were doing was wrong. Any thoughts on those, Shayla or Hugh?
On your first,
Go ahead.
go ahead, Shailen.
I was just going to highlight a quick comment about policies. I mean, certainly if you're doing a training, you're going to have a training record to show that individuals have taken the training, that they've done it, and presumably that they've understood it. Many training platforms now have interactive platforms where you're doing sort of knowledge testing throughout the training, and certainly those are higher level, more interactive trainings. But I'd say as well, it's great still to at least have a good old employee acknowledgement of handbook or of policy on hand, and to make sure that you have those, that they're updated when you update your policies, that you get a new acknowledgement signed from employees. Those are documents we rely on all the time in litigation and arbitration. And so just a reminder to be getting those and updating them.
I absolutely agree with that. Just one follow up on what Ina said about, if the text or messages don't actually refer to the employer, do you still act on them? I think you have to look at the context a lot, but yes, you can. And I think the one thing that you have to consider is the audience or potential audience. You can't always determine what the audience is, but if you can, and it's a group of employees or customers or employees of customers or suppliers, then I think that the inference can be more easily drawn that it connects to the employer.
I'd add too, sometimes it's difficult for employers to actually get the full picture of what's happening online or in the messages. I mean, certainly in a situation with a 5-person WhatsApp chat, you can't really infiltrate your way into the chat, and that would open up a whole nother can of worms. I dealt with a situation recently where an employee was posting in a private community group, so a Facebook group where you had to join to saying you live in that community, you're part of the group. There were over 1,000 members in that group, but it was still private in the sense that you had to apply to join it. You had to be a part of that community to join it. The employer heard about what was happening, but wasn't actually able to access the group and didn't have a full complete picture of what was in that group. And so there was a bit of an argument there in terms of, well, is it a private group? And certainly we argued it's not a private group. There's 1,000 people in this group. It's a small community. It is a large group, but just because we can't put our HR person into the group to get a full picture doesn't mean that it's still not causing an impact in the workplace. And they had received text messages and screenshots about what was happening in this group. And so we relied on those as opposed to really the individual original posts because we couldn't really get a hold of those.
And I'm just going to jump back in there to say that the very early cases that involved off-duty social media posts were almost all Facebook posts. And even a community of 50 people, 100 people, 300 people was large enough for arbitrators and adjudicators to find that this is problematic. So you may have a private group, but even with a small group of people, if you're posting about your employer affecting your employer's reputation, that's good enough for arbitrators to uphold it as a problematic post. So the numbers may not always give us the kind of the full picture. Okay, I think we're going to wrap it up. Thank you everyone for attending. You will be redirected back to the agenda to choose your next session. If you do have any questions, please feel free to connect with any of us directly. Our contact information is going to be on the agenda. I hope you enjoyed the presentation and enjoy the rest of the afternoon.